Good morning. My name is Elisa Scally. I'm a partner with Gowling WLG, practicing in the Employment, Labor, and Equalities Group, which we like to call the ELE Group. On behalf of the ELE Group, I would like to welcome you to the fifth webinar of our 2023 webinar series. During today's webinar, we will be exploring the world of extraordinary damages, those dreaded additional damages that an employee can claim beyond the traditional claim for pay in lieu of reasonable notice of termination. Now, to guide us through that discussion today, we have with us my colleagues Jordan Epstein, Tushar Ananzagar, and Chris Andre. All of my colleagues today, as you may know, are experienced employment counsel and members of our ELE team. Tushar and Chris practice out of our Waterloo office, and you will find Jordan in the Toronto office. A few interesting facts about our speakers that you may not know today. Or if you know Chris, you do know this, that he was raised in Saskatchewan. He is fiercely proud of being from the prairies. Growing up in Saskatchewan, though, it might surprise you that two of his favorite activities involve mountainous terrain. That would be hiking and downhill skiing, neither of which you can easily do in Saskatchewan, because what do they say about Saskatchewan, Chris? It's so flat you can watch your dog run away for 3 days.
It's not 3 days. It's 2 days.
Oh,
Lisa.
okay.
It's never more than 2 days.
Thanks for that clarification. Jordan, he is our expert when it comes to children's playgrounds. Thanks to his 3-year-old son, Jordan can give you a detailed ranking of all the playgrounds within a 5-kilometer radius of his home. So what's the verdict, Jordan, on the best playground?
Well, for those in the Toronto area, my number one choice, or rather my son Liam's number one choice, is Art Eggleton Park. It's on Harbour Street, just east of Ossington Avenue. It's got the requisite slides and a splash pad in the summer, but perhaps most importantly, there's an ice cream shop around the corner.
All right, so that's a great pitch for that playground. And now when you go, it's going to be very crowded. Tushar loves learning new languages. He's currently working on his Italian in anticipation of his upcoming trip to the beautiful country of Italy in 2024. So let's quiz Tushar on his Italian and see how he's doing. How do you say beautiful country in Italian, Tushar?
Good one, Elisa. I have to say this with my hands up, right? So il bel paese.
Great, that's amazing. Good job. Okay, so before we begin our program today, just a few housekeeping items. There will be a PowerPoint, but this PowerPoint will be sent to you following the webinar. It is also being recorded, so that recording will also be available to you. It will be sent to you with the PowerPoint, but it will also be accessible on our website, where you will also find all of our previous webinars. So if you're interested in viewing those, please go to our webpage. And finally, if you have questions throughout the presentation, please add them to the Q&A, and our speakers will do their very best to address those questions throughout the webinar today. And one last thing, in the chat, you will find the link to our webpage if you don't already have it. So now I'd like to turn it over to Jordan to start our program.
Hi, and good morning, everyone. We thank you for joining us today. I hope you have a fresh cup of coffee in hand for what is sure to be an interesting conversation about extraordinary damages in employment law. We're going to first discuss some core legal principles, explore a practical discussion, present some hypothetical fact pattern scenarios, and provide general practice tips for best practices to avoid these types of claims. We'll leave some time at the end of the presentation for questions, but as Elisa said, we encourage you to submit questions using the Q&A feature in Zoom. We'll try our best to answer questions during the presentation. Next slide, please. But before we begin, a quick legal disclaimer. Despite being employment lawyers providing commentary regarding employment law topics, this presentation is not intended to be legal advice. Because this is a high-level summary overview, it is simply impossible to cover all of the relevant details. For any specific legal advice, please contact any of us offline. We'd be happy to meet with you and provide proper advice customized to your specific situation. Next slide, please. In order to understand the damages that go beyond reasonable notice, it's helpful to remind ourselves what this fundamental term means. So here's a refresher of the basic concept. Remember, employers are generally permitted to terminate employment for business reasons on a without cause basis by providing employees with prior notice of termination or pay in lieu of notice of termination. This is the most typical employment dispute that we handle. An employee claims that their employment has been terminated without sufficient notice of termination, and in these cases, employees claim damages for pay in lieu of notice of termination. The value of damages is based on the minimum amount of termination entitlements prescribed by the Employment Standards Act, the details of any written termination clause of an employment agreement, and the greater entitlements to reasonable notice of termination under the common law. Now, this concept of reasonable notice is assessed in each individual case. It's intended to reflect the length of time the employee is likely to need to secure comparable employment from the job that they just lost. It considers the following factors: an employee's age, length of service, character of employment, and the availability of alternate work. Now, us employment lawyers, we spend a large part of our practice dealing with reasonable notice claims and drafting employment contracts to prevent employees from receiving their full common law entitlements. Today's presentation considers the damages claimed by employees that go over and beyond the reasonable notice claims. Next slide, please. Now, extraordinary damage is the term for the additional group of damages claimed by employees that are beyond the traditional claim for reasonable notice. These are damages that employees can seek when a reasonable notice does not adequately address the employer's conduct and the impact it might have had on the employee. As we'll explain today, these damages compensate employees for other losses suffered in the context of employment and punish employers for bad behavior. Now, despite the frequency of claims, these damages are only actually awarded in rare and exceptional circumstances. Extraordinary damages for extraordinary circumstances. And we're going to talk about those circumstances today. Next slide, please. Today's presentation will discuss the 4 main types of damages that are most commonly sought by employees. It's moral damages, damages for breach of duty of good faith during employment, punitive damages, and damages under the Ontario Human Rights Code. These concepts and legal terms have evolved over time, which can sometimes lead to confusion. My colleague, Chris Andre, is going to discuss the developments in this area of law and how we refer to the terminology.
Next slide, please. Thanks, Jordan. I don't think it's unusual or unexpected that they would get the older guy to talk about the history of damages in wrongful dismissal law. My colleagues were more concerned about their Halloween costumes than they were about the development in the law when I started practicing. When I was a baby lawyer in the early 90s, there was no such thing as wallets, Honda and keys, those kinds of things. That all happened as I was developing in my practice. So the starting point for extraordinary damages was sort of the concept originally was when only damages in lieu of reasonable notice could be awarded. There was no recognition of the psychological impact of a termination on the employee. The reasoning for that, as Jordan mentioned, was employers have the legal right to terminate the contract of employment. Really, there's 2 ways: for cause, not for cause. Where it's not for cause, we're talking about the concept of reasonable notice and how much notice the employee is entitled to. The courts and the law did not really have much time or inclination to talk about what psychological impact that was having on the employee when their employment was terminated. It became, the reasoning was the normal distress and hurt feelings resulting from the dismissal were not compensable because the employer had the absolute right to terminate the relationship. There was nothing unexpected. There was nothing illegal, provided that they gave the reasonable notice. That general concept that the normal level of distress and hurt feelings does not or is not compensable, that continues. That remains even to today. But there has been, over the development of the law, a recognition of the psychological impact that this has on employees. So what happened was there was a development of aggravated damages. That was sort of the overarching term. What was unique about aggravated damages was it was designed to address extreme hurt feelings, so more than the normal level of upset. But it was only awarded where there was a separate cause of action or an independently actionable wrong. That latter term is a bit difficult to put your arms around, but a separate cause of action would include an intent to cause harm to the employee or something of that nature. It wasn't just the impact on that employee was greater than what it might have been on another employee. The second element was, and the amplified level of upset was in the reasonable contemplation of the parties at the time that the contract was formed. I'm going to let you in on a secret. That's a bit of a legal fiction. It is highly unlikely that the parties gave a lot of thought to the level of upset that the employee would suffer if the contract was terminated in a particularly nasty way by the employer. I think one could say that the reasonable contemplation of the parties, the word reasonable there really means in hindsight. I think we could insert. So what happened, that was the law up until about 1997. In 1997, I remember it was I was attending a seminar on a Saturday morning. The Wallace decision was released Friday afternoon, the day prior. I arrived at the seminar, and whatever the topic of that seminar was, no one was talking about it anymore. Everybody was talking about the Wallace decision. And what the Wallace decision from the Supreme Court of Canada said was, if the employer breaches the duty of good faith and fair dealing in the manner of dismissal, the employer will have to pay additional damages. So in the way that the court decided or defined it in that case was that the employer had engaged in conduct during the course of dismissal that was unfair or in bad faith by being, for example, untruthful, misleading, or unduly insensitive. It required or stated that employers needed to be or need to be candid, reasonable, honest, and forthright with their employees. So those are a lot of adjectives with respect to the nature of the conduct of the employer. You know, the question arose immediately, well, how honest do employers have to be? A couple of things come to mind in that regard. People were very concerned that you always had to tell the employee the real reasons for termination. And I don't mean that you are, you know, engaging in discrimination or something like that. I'm talking about, you know, you're not a particularly good employee and we don't want to hurt your feelings, so we don't want to tell you that you're not a good performer. Rather, we're going to characterize this as a restructuring or something like that. Another discussion point that was very hot was whether employers had to disclose the plans for a future restructuring in advance of the execution of that restructuring. Are we being dishonest such that we're going to suffer additional damages where we don't tell the employees that we have been planning for the last 3 months to terminate a whole bunch of you, including this individual? Can we be subject to additional damages? So those were the subject of the debate at the time. Another piece of the debate was what period of time does the manner of dismissal cover? Does it cover long before the dismissal, just immediately before the dismissal, the moment of dismissal, immediately after dismissal, long after dismissal? Those were the debates that were going on at the time. What is the time frame that constitutes manner of dismissal? When are we subject to additional damages? And it was found over the course of the development fairly quickly on after that decision that the conduct preceding and post-termination, including going so far as to cover periods during litigation, was sometimes captured. And so the last piece was the measure of damages. The measure of damages under Wallace was an extension of the notice period. That was just a clumsy decision at the time, mostly because it did not align with contract concepts. It also provided, it overcompensated high earners, because if you gave an additional 2 months to a high earner, you were compensating them for their hurt feelings with more money than you were compensating someone who suffered the exact same conduct and was equally upset, but was a lower earner. They would receive less money. So it wasn't a very good method of calculating damages. And the other problem was where the employee mitigated their damages by finding replacement employment. What happened to the monies that they would have otherwise received because of the misconduct of the employer? In theory, it disappeared because the employee had mitigated. So it wasn't a very good method of applying damages or awarding damages. Then in 2008, Keys and Honda came along. And what it did was we got rid of the Wallace bump, which is the additional damages, and instead started talking about moral damages. And what the way that it was described is if the employee can prove that the manner of dismissal caused mental distress that was in the contemplation of the parties, those damages would be awarded. So it really got rid of the independent actionable wrong concept. It remained that the level of distress needed to be higher, but you had to show that it was directly related to the conduct of the employee. Whatever damages or hurt feelings the employee suffered was caused by the conduct of the employer. It got rid of the arbitrary extension of the notice period, which was an important development. So some examples of the kind of conduct that was discussed in Keys were attacking the employee's reputation at the time of dismissal, so alleging cause when there is none. Misrepresentation regarding the reason for the termination, being dishonest, and I think being more than simply trying to save the employee's feelings. The dismissal was meant to deprive them of a future right, pension right, or permanent status. And then it got down to things like refusing a letter of reference or failing to fulfill statutory obligations. The debate around, what the period is for the manner of dismissal continued. So are we still covering, the period immediately around the dismissal, or is that period extended? And that was the subject of some debate. Next slide, please. So here are the concepts that I was talking about in terms of the Wallace damages and then the development of Keys and Honda. So it was something that required an additional level or a higher level of upset, and then compensatory damages for actual loss or damages suffered. That language around untruthful, misleading, or unduly insensitive, candid, reasonable, honest, and forthright, that continues. That's where we are today. The development of the law, however, continued. And then, next slide, please. We got to a new case in 2014 called Basson and Renew. And this was not an employment law case. It was a case between two commercial parties. But what the law, as a result of this case, developed was the duty of honest performance during employment or during the entire length of the contract. And so what we did was get rid of that, what is the manner of dismissal? We're no longer concerned about specifically the time frame around dismissal. We're talking about honest performance throughout the entire length of the contract. So what the case talked about was a general organizing principle of contract law, saying that there's a duty to act honestly, and damages for the breach of this duty are measured in the same manner as we were discussing earlier in terms of the level of upset of the employee. I want people to feel more comfortable around that duty of honesty. Whenever we talk about honesty, we're talking about, or people get very concerned about, well, do I have to tell my employees everything? And the answer is no. You do not, the way that this has been described is contractual parties must not lie or otherwise knowingly mislead each other about matters directly linked to the performance of the contract. It does not impose a duty of loyalty or a duty of disclosure. It does not impose a fiduciary duty or a duty that puts the interests of the other contracting party first. It does not require a party to forego advantages that flow from the contract. So you're not restricted in exercising your right to terminate employment. And I think that the concepts of honesty continue to be what they were under Wallace. There is no obligation to disclose that the individual is involved in a restructuring or is being considered as part of a restructuring. In some cases, we have seen situations where the employer is dishonest in terms of the reasons for the termination in an effort to save the employee's feelings. Well, that has not led to damages. This also largely addressed the timeline issue, as I discussed earlier. What I will say about sort of where this has taken us, it has resulted in an avalanche of allegations of dishonesty in those demand letters and in those statements of claim that we receive, but it has not resulted in an avalanche of awards for breach of the duty of honesty. And I think if I can leave you with one thought, the duty of honesty, I think it's one of those things where it's not easy to explain, but it's relatively easy to identify if it has been breached. And so we're going to talk later about, you know, the specific kinds of practical ways that we think you can avoid any risk of being accused of breaching this duty. So at this point, I'll turn it over to my colleagues.
Thank you very much, Chris. And good morning once again, everybody. So the duty of honesty actually factors into the analysis of punitive damages. That's a perfect segue. And so what are punitive damages? Punitive damages are extraordinary damages that are based on the actions or inactions of a party, either prior to, during, or in some cases after the end of the employment relationship. And while the focus of this presentation is on issues facing employers, excuse me, on the management side, it should be noted that in some employment scenarios, punitive damages could very well flow against an individual or a group of employees, not specifically the employer. We're just going to focus on the management side today. So when are punitive damages issued? The courts will award punitive damages where actions are harsh, vindictive, reprehensible, and malicious in nature. They're extreme in nature. By any reasonable standards, they are deserving of full condemnation and punishment. And so there are probably dozens of employment cases being litigated as we speak today, thousands probably by the end of this year. Only a handful of them will attract punitive damages. What are the elements required to substantiate an award of punitive damages? The plaintiff basically has three elements or objectives to meet. They have to prove that the defendant's conduct is reprehensible. We'll talk about that. They have to prove that the defendant committed an actionable wrong that is independent of the underlying breach of contract, in this case, the wrongful dismissal. They have to demonstrate that the punitive damages award, when it's added to the compensatory award, is required to punish the defendant and meet the objectives of retribution, deterrence, and denunciation. So let's talk about the first element, the employer conduct. A very quick practical summary of employer conduct that has been found to have been reprehensible: conducting a performance review in bad faith to disentitle an employee from a bonus, terminating the employee rather than conducting an investigation into allegations of harassment, conducting a biased and or unfair investigation, terminating an employee while alleging fraud without actually telling them what they did, alleging just cause when there are no reasonable grounds, offering a reference letter in exchange for the employee's resignation, issuing a counterclaim to strategically intimidate the employee. So this is during the course of litigation, making defamatory statements about the employee that undermine the individual's reputation in the industry. These are all proven factoids, let's say, that have come out of decided cases. And it's quite clear that they breach that duty of honesty and fair dealing. And so a brief comment on trends that we're spotting, because this is a broader level overview. Courts have historically found that punitive damages are appropriate where an employer actually sets out, so there's a level of intentionality, to harm the employee in some way. The opposite wasn't historically the case. Employers weren't generally punished, at least not via this mechanism, for negligence. However, there are a handful of cases that have come out in the recent past which suggest that there may be a shift towards punishing employers for certain inadvertent acts, for instance, as a result of a failure to issue a timely record of employment in one particular case. So those are elements, number one, on the basis of conduct that could attract damages. Element number two, the plaintiff has to prove that there has been some kind of independent actionable wrong. An actionable wrong could be, but it doesn't necessarily need to be an independent tort. It could also be found in, as Chris had mentioned earlier, a breach of the duty of good faith and fair dealing. Similarly, a breach of a distinct and separate contractual provision in the employee's employment agreement, or a breach of a fiduciary duty. There's actually quite a broad net of independent actionable wrongs that could factor into this analysis. The third element, they have to prove that the punitive damages are required. This is typically the hardest part of the test because compensatory damages, all the various other types of damages, they already carry an element of deterrence with them. And if they're sufficient in the eyes of the court to meet the goal of punishment and deterrence, there really won't be a need for punitive damages. So this is a high threshold, this three-part threshold. And in essence, the plaintiff has to prove that the court must go above and beyond to condemn that behavior in question. So let's talk about how much. Punitive damages awards, they vary quite significantly, but they must be proportional and they must avoid double compensation with the other heads of damages as we'd spoken about. So what is considered here? Blameworthiness is a big one. The more reprehensible the conduct, the higher the rational limit to the potential award. So if the employer knows it's doing something wrong and there's no rational justification for it, the award will be higher. If the misconduct was planned, if there was intent, motive, whether the defendant tried to cover its tracks and conceal what was happening, these are all factors that can lead to an aggravated damages quantum. The degree of vulnerability of the plaintiff, there are lots of factors to consider here. And this is a holistic analysis. It varies from case to case. And so because of this, because punitive damages are typically rare, there's actually quite a wide range of them. We typically see damages ranges in the $5,000 to $50,000 range across the country. But more recently, as we'll get into a little bit later, courts have pushed well into the six figures. And 500,000 is currently the high watermark in this province for damages, punitive damages. Next slide, please. So we're going to talk briefly about human rights damages before we get into talking about a specific case. We have a narrow focus today. We have and for years now dedicated entire webinars to human rights issues, including the accommodation process, the undue hardship threshold, best practices for dealing with accommodations, et cetera. And so for our purposes, we're just going to be talking about remedies as they relate to this matter. So when are damages awarded in the context of a breach of a human right? First and foremost, there has to be an appropriateness of the remedy. So the damages have to be appropriate. To determine if damages are appropriate, the adjudicator, or in some cases a court, will consider first the objective seriousness of the conduct, and second, the effect the conduct has on the applicant. Relevant factors are the humiliation experienced by the applicant, the extent of hurt feelings experienced by that person, the loss of self-respect, experience of victimization, seriousness, frequency, and duration of the offensive treatment. Now, there are a number of non-monetary remedies that are available, including implementing training or requiring the employer to put in place an anti-discrimination or harassment policy. We'll leave those all on the side. What are the monetary remedies? The monetary remedies, depending on the jurisdiction with some overlap, are typically compensating the complainant for lost wages and benefits as a result of a contravention, reinstating the employee from the date of the discriminatory breach through to the date of the decision with back pay. That's a significant one. Awarding damages for injury to dignity, feelings, and self-respect. And depending on the jurisdiction, these damages can be significant, especially if there's no upper limit that is imposed by statute. The reinstatement one I want to just come back to for a moment here, because it is a potentially big one. It can mean significantly more employer liability than in a common law reasonable notice case where awards are typically capped at 24 months. There is an Ontario case actually that came up in our prep for this, where an employer was obligated to reinstate an employee with back pay over 9 years after the alleged breach, 9 years. And COVID-19 has not helped this situation. It's actually significantly increased processing time, with some cases coming up for their first day of hearing over 3 years after the alleged wrongdoing, with all of the challenges associated with that, fading memories, witness availability, et cetera. But at the end of the day, the employer doesn't get a break because of these systemic delays. A brief note on damages trends before we move on. There are now multiple cases where human rights damages awards have trended up into the 6 figures and exceeded 6 figures, particularly where we have a poisoned working environment, together with harassment allegations, together with breaches of other protected human rights. So before the HRTO, the current high water mark is $200,000 in a 2018 decision in AB versus Joe Singer Shoes Limited. That was a sexual harassment case, repeated assault, harassment on a number of grounds, both in the employee's home and at the workplace. The applicant was also subject to threats aimed at exploiting her vulnerability as a single mother and as an immigrant. So a number of red flags going up. There was a 2020 decision, another egregious sexual harassment and disability accommodation related case. Again, a combination of these protected characteristics. And that was an award of $170,000. And more recently in 2021, during the pandemic, the BC Human Rights Tribunal awarded its highest ever award, $176,000 in damages for injury to dignity. So while most of these damages ranges fall, or these cases will fall in the $5,000 to $50,000 range across the country, depending on the jurisdiction, there certainly seems to be a trend towards increasing damages and higher damages awards. Next slide, please. So we're going to talk briefly about this particular case. It's not a new case. It's well publicized, but it still serves as the high watermark for punitive damages. $500,000 in punitive damages, $250,000 in moral damages as part of a broader, I will say, eye-watering $1.7 million damages award. I think it's worthwhile to talk about the facts, because the facts are really what drive these issues. And look, we're dealing with a reputable employer here, and we're dealing with a vicarious liability issue where the employer is responsible for the conduct of its employees. But it really shines a light on the types of facts that could potentially result in a punitive damages award. So we have a plaintiff who's on a solid job track, multiple promotions, solid performance reviews. She's got positive reviews, and one day expected that she would, one day be placed in a very high level executive position, and one day be promoted to chief merchandising officer as part of the evidence in this case. In 2008, she signs an agreement which says that she's going to get 2 years of contractual severance in the event of a without cause dismissal. In 2010, all of a sudden, she's removed from her position and told that it's due to a restructuring. And she's told that the company doesn't know what it's going to do with her, which is a pretty significant red flag. Over the next month, management tries to identify new roles. However, none of them were for positions with anywhere near the same level of responsibility. And some of them were actually overseas in South America or Asia. Another red flag. Shortly thereafter, the employee is demoted and has to report to someone who was previously on the same level of her seniority in the organization. Another red flag. This was especially humiliating for her because the employer announced that decision to 500 staff via email. Another red flag. She is not told what her duties will be for 10 days after that change, that restructuring change is made. Another red flag. Another management executive changed her internal performance reviews and changed the scores, which basically made her ineligible for a promotion. Another red flag. She attended an 8-week university course. When she returned, her belongings were removed from her office with no explanation. Another red flag. And in November of 2010, she attends a meeting where she's offered a lower position, which included a new extended probationary period or severance pay. And that was not accepted by her. And on November 19th of 2010, she's dismissed. without cause. And although she's entitled to a severance package of 2 years as per the terms of the last agreement she signed in 2008, the employer paid for salary continuance and those payments continued for a period of time, 11.5 months, but then they all of a sudden just stopped. And so the court considers this litany of red flags. And I'll reinforce again, this is a reputable company and we're dealing with a subset, a small facet of the employer. But every bad manager, supervisor, and every bad decision that is made by those individuals could be the subject of these types of cases. And so the court awards $250,000 in moral damages plus $500,000 in punitive damages on top of the other compensatory damages. And so what are the takeaways here? Honesty and fairness are critical. A key factor in a number of those managerial decisions related to honesty and misleading the employee into thinking that they had a bright future before just pulling the rug out from under them. And I'll note that a portion of the moral damages of $250,000, 50,000 of that 250 was actually related to litigation tactics. So withholding critical information during the trial process and essentially hardball tactics, a penalty for hardball tactics. So what does this decision signal, or what did it signal? Further to Chris's comments, there's a trend now where courts increasingly scrutinize not just how a decision is, not just how a dismissal is conducted in that narrow window of time before and after the dismissal, but also in some instances, the months and years leading up to the dismissal and post-dating the dismissal in the litigation context. We're talking about performance evaluations and relatively innocuous seeming evidence. So quite clearly in this case, a number of red flags, and we'll keep these points in mind when we're discussing practical facts and circumstances following up in this presentation. Jordan, I'm going to pass it over to you for the next slide.
Thank you. We've now provided a background summary of what these damages are, and now we'd like to have a practical discussion about what impact these extraordinary damages claims might have on the process. But first, why? Why do employees so often seek extraordinary damages when they are so rarely awarded? And Chris aptly referenced the situation as an avalanche of demands, but not necessarily an avalanche of judgments. It's important to note that there are circumstances when it is certainly appropriate for an employee to make claims for extraordinary damages. But those disputes almost always settle prior to the trial process, for employers to avoid the embarrassment of a public decision, but also the costs and additional financial exposure associated with defending these type of claims. Where there's smoke, there's sometimes fire. If there is a real chance to exposure for extraordinary damages, your employment lawyer should recommend early settlement. But with that being said, there are more than a fair share of employee claims that seek extraordinary damages when the merits of the dispute don't necessarily call for it. And employees bring these claims for a variety of strategic purposes. For one, these claims optically make the value of a dispute much larger. A lawsuit for $50,000 for traditional wrongful dismissal damages can quickly escalate it to $250,000 and beyond in total value when including other claims for damages. In theory, some employee lawyers might think that a larger valued claim catches an employer's attention or makes the dispute seem more important than it really is. As part of negotiating strategy, it might be easier to settle for just reasonable notice damages at an earlier stage of the process if the value of the lawsuit looks much larger on paper. Increasing the value of a claim can also bump a lawsuit from the small claims court jurisdiction up to the superior court. And remember that the jurisdiction of the small claims court is currently $35,000. It used to be $25,000. And while this number is relatively low in terms of economic value, for a number of short tenured, low valued employees, $35,000 and below is likely where their reasonable notice damages ought to lie. But plaintiffs nonetheless try to avoid the small claims court for a few reasons. There's mandatory mediation in Toronto Superior Court actions. The small claims court does not have that same process. There are certain tools available to plaintiff employees to try to expedite the scheduling of the early steps in a superior court process. And a superior court action might force an employer to incur more legal expenses than they otherwise would spend in the small claims court. And this is a leverage tactic. Instead of the employer paying their counsel for a lengthy litigation process, perhaps that employer might be motivated to spend a little bit less or a little bit more promptly on a reasonable settle amount at an early stage of the process. But by and large, the primary reason for claiming extraordinary damages is for potential tax benefits. A typical claim for wrongful dismissal damages is paid to employees as income, less regular statutory deductions. Extraordinary damages, on the other hand, are not characterized as income. They are paid to employees without tax deductions at the source, and in some cases, without any requirements for employees to report the payment to the government. It is a well-known secret that employment disputes often settle by allocating a portion of settlement funds to tax-free general damages. An employee's claim for extraordinary damages and human rights damages in particular provides an opportunity for this payment method. I should note, importantly, that there are potential tax consequences to employers and employees for misclassifying a payment of settlement funds and not remitting taxes when they really should be paid on these payments. But nonetheless, these payments are made tax-free to employees more often than not. Now, Tushar, I briefly mentioned the reasons why an employee might want to bring a lawsuit in the Superior Court. What type of impact do these extraordinary damages claims have on the litigation process?
Thank you, Jordan. And we'll move to the next slide, please. That's a great question. Because of the fact-specific nature of these claims, they are necessarily, let's say, longer and more drawn out than a typical case. There's a substantial investment of time and resources. Let's look at that Galea case as an example. We have a termination date that occurs in November of 2010, and then a case that moves through the system for a minimum of 6-7 years before a decision is issued. Because of this, they're significantly more expensive in terms of just legal costs. These usually cannot be dealt with using expedited or simplified litigation processes, such as summary hearings. Because of the fact-specific nature of these cases, the evidence that is needed is actually more often than not viva voce evidence or live evidence, which requires witness testimony. And so legal costs can be exorbitant. Depending on the case, they can range from between $300,000 to $500,000 or more, depending on the level of complication. And the same can be said of many other cases that we reviewed at a high level today, which resulted in those higher damages awards. So we're talking about substantial legal fees that are, again, very difficult to estimate because of all of the twists and turns that these cases tend to have. Discoveries can take months of cumulative time. And without going too far into the weeds, we had the Galea example, so I'll sort of circle back on that one. The trial itself, not counting pretrial discoveries, just the trial, went on for 28 days of hearing before the court. 28 days of hearing before the court. And that's just on the legal side, the legal costs, all of my previous comments. The actual operational cost, the lost time for purposes of witnesses, per diems, expenses, lost productivity of the typically senior employees or executives who tend to be witnesses in these cases. These things all add up and layer on top of the legal costs. And again, these are exceedingly difficult to quantify. And so I'm going to pass it over to Chris to talk about the employer's response to these types of allegations, claims when they do come in.
Thanks, Tushar. I'm not sure why they gave me the slide with the angry guy yelling into the phone. Maybe it's unintentional. But anyway, picking up on what both Jordan and Tushar had to say, and reflecting a little bit on the comments that I made earlier, all of the conduct of the employer is going to be or have an impact on the potential for additional damages. Therefore, the employer's response needs to take that into account. The first point that I want to make about that is you have the opportunity to make your own evidence, or you have the opportunity to give the employee and their counsel the evidence. So if the response of the employer is appropriate and measured and dispassionate to the degree that it can be, I think that's helpful to the employer. The fact that the employee or their counsel has sent a screaming hot letter does not necessarily mean that the employer should send back a screaming hot letter. It may be that the employer is better served, and I think in the vast majority of cases, an employer is better served by replying in a measured tone. It doesn't mean you have to agree, and it doesn't mean that you can't be emphatic in the denial of some of the allegations. But it does mean that the language of that response, whether it's in the form of a response to a demand letter or whether it's in the form of a statement of defense, needs to be, I think, measured. I think there's also value, and I know some employers get frustrated. I think we could compromise, or employers could compromise when they can. Again, doesn't mean that you have to concede all the points, but I think where the compromise can be given, I think it's going to serve the employer well. Hopefully, it's going to result in the resolution of the dispute without any litigation, without any undue wrangling. But at the very least, as things come to light and as you proceed through any litigation process, it is going to look better on the employer where there were opportunities to compromise and the employer did so. One of the bigger challenges, I think, in my experience, is managing the emotions of the managers. Many of the allegations that we are talking about, the misdeeds, now in the case that Tushar was referring to, it sounds as though the criticisms were deserved. However, in most of the cases, the criticisms are not deserved. There may be a difference of perspective or a difference of opinion, and in most cases, the manager was managing. They weren't being discriminatory, they weren't being harassing, they weren't being inappropriate or unfeeling or unfair. And so managing the emotions of the manager are important as well. Remember and remind the managers that many of these allegations are strategic, as Jordan was talking about, in terms of why do employees' counsel always make allegations of wrongdoing when there probably isn't much there. Often it's strategic. And so I think that can hopefully help turn the temperature down in terms of the reaction of that manager, and the same goes for the overall emotion or projection that is coming back from the employer. I don't know whether anyone has more to add on that, but those were my comments.
Perhaps, Chris, to echo your comments with respect to the challenges, and it's that emotional response that is often so hard to avoid when it comes to extraordinary damages. Some of these claims, they inherently elicit a more acrimonious and aggressive defense than the claim otherwise would have in the normal circumstances. Even the language surrounding a punitive damages claim, for instance, that Tushar referenced, with demand letters and statements of claim, they're going to call an employer malicious, high-handed, reprehensible. Now, for us employment lawyers, we glaze over some of these terms because we see them in writing so often. But our clients, when they're called a reprehensible manager that might be racist or sexist or prejudicial to another protected ground of the Human Rights Code, you better believe that they want to defend themselves and defend themselves aggressively. And what often happens is a snowballing of aggressive letters and correspondence from lawyers, when what really could have happened is a more pragmatic and results-oriented settlement discussion regarding reasonable notice damages. So sometimes the strategies that our friends on the employee side try to employ, they make this a more complicated case than it really should be, and that hurts chances of early settlement.
Wholeheartedly agree. Jordan, I think that's a great segue because I think we're gonna talk about some of those strategies and particularly the emotional response of individuals in a practical discussion, a fact pattern scenario that we've put together for the attendees today. If we can go to the next slide, please. Perfect. And so, gentlemen, I'm going to give you some background information about this this company, and then I'm going to turn it over to either one or both of you to talk through some of the issues, the risks, and potential concerns. So, bit of background. This fact pattern features an employee matter at ABC Company, a company that's based in Ontario. For the first few years, the HR director, Jill, worked closely with senior management at ABC Co. And all of a sudden, the CEO announces that they'll be pursuing an opportunity elsewhere and leaves the company. The CFO, Karen, will be taking on the role of interim CEO until a new executive has been recruited. And Karen, in this particular case, has a reputation of being a hard-nosed, I'm going to use your terminology, Jordan, results-driven or results-oriented manager. She's known for announcing quite publicly that those who don't perform up to her standards will be told to find another job immediately. And let's talk about Ken. Ken is an employee of ABC Co. with 25 years of service. He did not sign an employment agreement when he started with the company. He's currently 64 years old and holds the position of VP of Sales, reporting directly to the CEO. Quick fact, he's responsible for managing a team of 50 sales staff located throughout Canada. Next slide, please. So here's the first scenario. During the pandemic, Ken and his team achieved record sales, but after the pandemic in Q1 of 23, sales performance starts to decline, and Karen, the interim CEO, is not impressed. At the Q1 sales review meeting, Karen is visibly annoyed and confronts Ken. She repeatedly states that the Q1 sales results are totally unacceptable, and in front of every member of the sales team, she proclaims, "Our product sells itself." These are senior staff. When Ken leaves the meeting, he's visibly upset and on the verge of tears, and then shortly after the meeting, Ken emails Jill and says that he's going home for the day because he feels unwell. The following day, Ken emails Jill a 2-line doctor's note, which reads, Ken needs time off for stress leave, 6 weeks. Jill notifies Karen about the doctor's note, and Karen walks into Jill's office and says that Ken needs to be terminated for cause, effective immediately. So I'm going to turn this one over to you, Jordan. How should Jill advise Karen, and what are the risks here?
Well, to the extent possible, Jill should probably tell Karen to take a deep breath and calm down, because managing employee situations like this requires a measured approach. Jill should remind Karen of the risks and financial exposure associated with terminating Ken's employment, and try her best to convince Karen to not take any extreme steps that could end the employment relationship at that time. And what are the risks? Well, there's a laundry list of potential red flags and risks associated with this scenario. For one, terminating Ken's employment would come at a high cost in even the normal circumstances. Given Ken's age, length of service, and position, his reasonable notice damages are significant in itself. But Karen's course of conduct here is potentially adding fuel to the fire of a potential lawsuit. Terminating an employee for cause, no less, in response to a doctor's note can certainly expose employers to human rights damages and other types of extraordinary damages. Under the Human Rights Code, for one, the company has an obligation to accommodate Ken's medical leave and return to work. Moreover, we know from the discussion of the Basson decision that the company owes Ken a duty of good faith and honest performance during employment. It is not hard to see Ken build a pretty strong argument for extraordinary damages based on Karen's potential course of conduct here.
Thank you very much, Jordan. That's very comprehensive. And I think further to our discussion of the cases that we ripped through just a few minutes ago, the evidence of what's happening at the sales meeting, the insulting, the conduct in front of other employees, the humiliating behavior, potentially could be conduct that might attract punitive damages in some form of litigation. And so we'll move to the next slide. Okay, here's scenario number 2. So Jill was able to talk Karen, perhaps thankfully, out of terminating Ken's employment. Ken was eventually able to come back to work. And so he's back to work, but not until 6 weeks had passed. And after Ken's return, Jill schedules regular check-ins. He seems to be doing well. 2 weeks after his return, there's another sales results meeting, and the results aren't great. In advance of the meeting, Karen once again walks into Jill's office. She tells Jill that she has, quote unquote, conclusive evidence that Ken was stealing from the company, and points to a number of suspicious charges on his corporate credit card that were incurred 6 months ago. Jill reviews the charges in advance of the meeting and finds that they are food expenses on days that Ken has been traveling for work. Technically, they exceeded company policy, but by a few dollars each time. Karen tells Jill that she wants to confront Ken about the charges at the sales meeting in front of the sales team, his subordinates, and the senior staff. Chris, I'm going to turn this one over to you. How should Jill advise Karen, and what are the risks?
There are lights flashing, sirens blaring. This is headed potentially in the wrong direction. The starting point is that Ken's just returned from a leave of absence. Question whether there's a disability here or not. Arguably, there is a 6-week absence for stress leave. That may simply be something that doesn't rise to the level of disability. It may be an indication of an anxiety disorder. We don't have enough information, but I think we can feel quite comfortable that there is certainly a risk that it is a disability, and therefore we should be operating on the understanding that that is something that should be taken into account. The part where Karen is digging into 6-month-old expense claims, that is very troubling, because that is the kind of behavior that was sort of described or alluded to in the Walmart case and in some of the other decisions. The CEO should, it's not their job, I would think, to typically dig into 6-month-old expenses. That suggests that she's looking for a reason to discipline or fire Ken. And so when one is confronted with that kind of evidence, Jill needs to sort of be very conscious to say, it appears as though Karen is trying to generate or create cause to terminate rather than having the facts display themselves and coming to conclusions based upon, the objective facts that are presented. I recognize, as we point out in the fact pattern, that Ken is technically offside the policy in that he has submitted food expenses that exceed the company policy. But as you pointed out in your discussion, it exceeds it by, a few dollars. When one is traveling, and I suspect many of the people on this webinar have had the experience, when you're traveling in one city, you can't find lunch for less than $20. In other places, you can find lunch for less than $12. Eating fast food when you're traveling is not your best health choice. Perhaps you need to sit down and have something more healthy, which tend to cost more. That kind of context, if his territory is downtown Toronto versus a smaller center where the cost may be lower, those are the kinds of factors that need to be taken into account to determine whether this is a technical breach of policy and whether it requires sort of a corrective, course correction, coaching kind of conversation, or whether it amounts to cause. And then the whole idea of confronting Ken at a sales meeting, this is not the kind of information that should be confronted in front of anyone other than the immediate manager and perhaps HR. This is not the kind of thing that needs to be brought up, particularly where it is an old claim on a relatively modest issue.
Thanks very much, Chris. And just a quick follow-up question. So Karen is advising Jill that Ken is stealing. That's a point of evidence there. Jill is reviewing the charges. She sits down, goes through this analysis. There's a follow-up discussion about, the value of the expenses, technical breach of the policy. And then there's a statement here about intentionality. Karen tells Jill that she intends to confront Ken. Is that all fair game when it comes to the litigation process?
Well, from my perspective, again, this is not an issue that needs to be addressed in a public setting, so to speak. And so I think at this point, what needs to happen is Jill would suggest to her that this is something that can be dealt with in a one-on-one meeting, and the ferocity of the confrontation, I think, is, or the suggests that this is being overdone.
Totally agree. Thank you very much. And so let's move to scenario number 3. So in this particular instance, Jill is not listened to. Karen immediately starts to interrogate Ken at the sales meeting about the charges on the corporate credit card. Ken explains that the costs of the meals in his territory are higher than the policy limits. His clients are in Toronto, while some of the other sales staff who work in lower cost areas such as Kitchener, Waterloo can get lunch for $12. His lunches are comparatively more expensive, particularly if he's taking a client out. Karen doesn't really seem interested. She talks over him. She humiliates Ken by saying that he should have known better. He's already on thin ice because of his poor sales performance. Ken once again walks out of the meeting and is visibly upset. He leaves the office, goes home for the day, and the following day he's back on stress leave, and he submits another 2-line doctor's note in support of his leave. While Ken is off at this time, Karen walks into Jill's office and tells her that, okay, she wants to restructure Ken's department, and essentially Ken would no longer be the VP of sales, but would instead be reporting to one of his junior supervisors. This would effectively result in him taking a significant pay cut. So I'm going to turn it over to you, Jordan. How should Jill advise Karen, and what are the risks we're dealing with here?
Well, again, to touch on Chris's earlier point, it's concerning that Karen continues to interrogate and in this case, humiliate Ken at the sales meeting in front of his colleagues. If there was a legitimate concern about workplace policies, those meetings should always be conducted in a private setting. Making these accusations publicly in and of itself could be an act of bad faith that should be avoided. It's also concerning that Karen tries to demote Ken's position and reduce his salary. This could very well lead to a claim for constructive dismissal, in addition to the extraordinary damages that we discussed today and human rights damages if Ken's medical leave of absence played a factor in the reason and timing for dismissal. Jill should advise Karen of the potential risks here. While doing so, remind her of the company's obligations to accommodate Ken's medical leave and the company's duty of good faith, fair dealing, and honesty to all of its employees. But as a general note, like these type of situations, well, this is an extreme example, but versions of this scenario play out more often than not. And employers shouldn't play games and try to force employees to resign or manufacture allegations of termination for just cause when it doesn't really exist. In this case, like, it's obvious that the employment relationship here is not healthy. It's untenable going forward. There is no legal issue with the company terminating Ken's employment without cause and providing pay in lieu of reasonable notice of termination. That is the good faith thing to do in this situation. While the value of the severance package is going to be high, the legal costs associated with defending a claim will be much higher given this behavior and conduct.
Thanks very much, Jordan. We're going to take a look and see if Karen is listening. Can we go to the next slide, please? So scenario number 4. On the day that Ken returns to work from his stress leave, Karen calls Ken into her office and tells him that the sales department has been restructured, so she didn't listen. Ken is not happy, understandably, about the changes made, and he voices his concerns to Karen. In response, Karen terminates Ken on the spot. Ken asks specifically if he's being terminated for cause, because he's listened to webinars and he understands a little bit about employment law, to which Karen responds no. She calls security to escort Ken out of the building. She indicates that Ken's personal belongings will be shipped to his house. So all of his photos of his children and the stuff from his office. Several employees watch Ken being escorted out of the office by security, and Ken is visibly upset. After the call, Karen walks into Jill's office and tells her that she had some concerns about the meeting and that she is concerned about a lawsuit, but she really doesn't want to be perceived as a pushover. As Jill is drafting a termination letter after the meeting took place, Karen says that the termination letter should say that ABC will withhold Ken's statutory notice and severance until he signs a full and final release in favor of ABC Co. I'm going to turn it over to you, Chris. How should we advise Karen, or sorry, how should Jill advise Karen? What are the risks?
Well, the milk is spilled, the water's under the bridge, et cetera, et cetera. So at this point, the challenge will be for Jill and presumably counsel to try and make the best of a pretty bad situation. For one, there is it appears a change of strategy or a change of approach. In the meeting, Ken asked if he was terminated for cause. He said no, and then when the termination letter is going out, Karen is suggesting that you withhold the statutory amounts. Without getting too deep into it, because that's not the purpose of this presentation, you know, there is the highest level of or the highest standard of what we think of as cause being willful misconduct in Ontario. Without that willful misconduct, disobedience, willful neglect of duty, the employer has no obligation other than to provide the statutory notice and severance pay. And so from the perspective of trying to withhold that amount and requiring a release, that is entirely inconsistent with the conversation that Karen had with Ken, which is going to be seen to be dishonest. It's also evidence of her intention to manufacture cause when it doesn't exist. Again, another, as you pointed out, red flag for the kind of behavior that is at risk here. In terms of the human rights issue, I think we can feel more comfortable now when someone has been off twice for 6 weeks at a time, that there is something that likely amounts to or would be characterized as disability. So all of those human rights damages that were in play in Tuchar's discussion, I think, are now at the fore. And so it may very well be that there are additional damage for a human rights context, because Karen demonstrated that she wanted to terminate him immediately when he said he was off in the first instance. So I think that we can suggest that there's that factor, his absence is was a factor in her decision making. So I think at this point, what Jill is going to have to do is to advise Karen that there's not just a concern about a lawsuit, it's almost assured if there isn't a resolution here. And so what they should focus their attention on is making the best of a bad fact pattern. This will be where structuring for damages other than wrongful dismissal damages, i.e. general damages for to resolve a human rights allegation, are going to play a part likely in any settlement.
Thanks very much, Chris. And let's move to the next slide and take a look and see whether or not we do in fact have some sort of legal proceeding on the back end of this. So scenario number 5, Ken's statutory notice and severance are actually paid out. So Jill was successful in her campaign to avoid that aggravated factor, and his benefits are maintained post-termination in accordance with statute. And 2 weeks after Ken is terminated, a process server delivers Ken's statement of claim to ABC Company as predicted, Chris. The statement of claim alleges that Ken was wrongfully dismissed, entitled to over 30 months of notice, moral damages and punitive damages, aggravated damages to be calculated as of the date of trial. Karen is livid. Karen insists that the company should assert after acquired cause against Ken in its statement of defense and in its subsequent legal position. Jill asks what the cause allegations would be, and Karen refers to the meal expenses that we spoke about 2 scenarios ago, the charges on the credit card for trips to Toronto. Karen asks Jill to instruct the company's lawyers to play hardball with Ken. She also asks Jill to send an email out to members of ABC's industry association, telling them that Ken had stolen from the company and is essentially unemployable. I'm going to go to you first, Jordan, but Chris, feel free to jump in. This is our last scenario. How should Jill advise Karen here, and what are the risks?
Well, we know from the Galea and Walmart case that extraordinary damages can be awarded against employers for bad faith conduct during the litigation process. And important to note that accusing an employee of theft is a serious matter. These are real allegations. The court will scrutinize these allegations and could very well punish an employer for making them without any real basis for doing so. And at this point, there's a lawsuit filed, the company's employment lawyers are involved, and I'd like to think that these employment lawyers are directly advising Karens of the risks of this process. They ought to be telling Karen that this litigation strategy will very well end up costing more money in legal fees and lead to exposure for extraordinary damages that are over and above the money that the company likely owes Ken anyways.
If I can jump in, this is an example of the Employees Council making overreaching in some respects. The 30 months notice. We all know that the generally recognized cap is 24. The fact that they have claimed 30, I'm sure they will have an argument to support that. It's unlikely, even in this fact pattern, that they're going to get damages or wrongful dismissal damages greater than the generally recognized cap. But this is an example of the employee reaching further, and it requires the employer to be measured in their response. And she is obviously showing little measure. After acquired cause is what it sounds like. You find out information after the person has been terminated. In this case, obviously, she knew about the information before the employment was terminated, and therefore that would be to rely on that kind of evidence simply to paint Ken in a bad light or to make him a less sympathetic character in this opera is not a good litigation strategy. And the note to the industry association, as Tushar described, that is well over the top, because you're now calling into question his morals, and you are poisoning the well for him finding replacement employment, which cuts the employer's nose off despite its face, because its only real defense in this case is mitigation of damages through reemployment. So it is a terrible strategy.
Thank you both. Lots of different ways to put more money in the pockets of Ken, I think, at the end of the day. Jordan, I'm going to turn it over to you for the next slide, tips to avoid claims.
Thank you, Tushar. We've covered a summary of the law. We've explored some hypothetical scenarios, but how can employers avoid allegations of extraordinary damages? I think maybe the easy answer is don't be like Karen. Don't do any of the things that she did in those fact patterns. But one thing that we want to stress today is an employer's duty of good faith. Employers should be honest, forthcoming. Don't try to mislead your employees. In addition to potentially mitigating against extraordinary damages, these are just basic tips to manage any employment relationship. And when it comes to termination, there are strict requirements prescribed by the Employment Standards Act. The ESA outlines when certain termination payments must be made, the types of benefits that must be continued, and the specific period of time upon which these benefits must continue for, and even the specific content that must be included in a termination letter. Extraordinary damages can very well be the result of failing to provide an employee with the bare minimum statutory entitlements or following the requirements set out by the ESA. There can be financial consequences as well for failing to issue a record of employment in a timely manner. The ESA is highly technical. Details matter and mistakes happen all the time. For example, there could be a clerical error calculating an employee's final pay. Oftentimes, we see mistakes when calculating an employee's accrued and outstanding vacation pay at termination. When mistakes happen, and they will happen, it's important to correct them promptly and without conditions. It is never appropriate to leverage the correction of a payment error as a settlement term. You should connect with an employment lawyer to make sure all companies have the proper procedure when it comes to employee terminations, and you don't inadvertently create situations that expose your company to unwanted claims for extraordinary damages. And that touches upon some of the situations and conduct following termination. And Tushar, I'm wondering, are there any types of ways that an employer can proactively try to mitigate against these claims even before termination?
Thanks very much, Jordan. Yes, absolutely. We talked through a couple of the fact scenarios. First and foremost, I think is your management and supervisory team should be aware of the types of conduct that can attract these enhanced exemplary damages. So perhaps a level of education or awareness would be helpful. That's a background piece. But when something comes up, rather than trying to spin it some way or adopt an aggressive litigation strategy with respect to that issue, the last bullet point here, I think, is particularly salient. If there is a mistake, own the mistake, fix the mistake ASAP yesterday. In today's day and age, I'm gonna steal some of Chris's terminology. We're in the age of the relentless slaughter of the termination clause, particularly in the province of Ontario. And the less there is to criticize on the part of the employer, the lower the likelihood of an enhanced or exemplary damage claim coming on the back end of litigation. These are publicly reported, issued and publicized decisions. They're talked about in forums such as these. And so if it's something that comes up and there's a way to fix it, then I would strongly recommend fixing it immediately. Chris, some comments on your side?
Yeah, the thing that I wanted to stress is a comment that Jordan made, and that is, connect with an employment lawyer. This is the advertisement, but I think it's an advertisement for services that are of value. We can help with these situations to try and steer between the rocks and get you into the harbor safely. In many of these cases, there is no risk-free way to do it. There's always risk, but hopefully what we can help you do is get from where you are to where you hope to be with the fewest number of bruises. And one of the things that I think is important in that process is to document the process. You've got the opportunity as the employer to document and effectively create your own evidence. And I don't say that in a way that is misleading or underhanded. I mean, create the documentation that shows the reasoning to why you got to the conclusion that you got to. Even if at the end of the day somebody disagrees with the reasoning, at least you've documented that you took a process that was thoughtful and reasoned and not manipulative and not dishonest. And then when someone alleges that it was also influenced by human rights considerations or something else, you've got evidence that says, no, here's the reason why we got to where we were. And you may not like it, you may not agree with it, but that's how we got there. And I think that investment of time and energy by Jill, by the organization, is going to help lessen the total spend. Yes, lawyers are expensive, and yes, our advice costs. But if we can avoid these really significant outcomes, at the end of the day, we think that there is a significant savings. And setting the tone for that interchange between opposing counsel and us as your representative or the employment counsel helps keep that number down. If all we've done is poke them in the eye throughout the process, why would they compromise less than what they might get at the end of the day? Maybe they're trying to set an example or make a point. If we can take that motivation away, hopefully we can get the matter resolved for something less.
I think that by and large sums up our substantive commentary, but there's been a really active discussion going on in the Q&A. Maybe I'll pull up some of these questions. We appreciate all of the questions and hope you've all enjoyed today's presentation. There was an interesting question that I found with respect to the non-payment of reasonable notice at termination. This is from an anonymous attendee at 9 o'clock this morning. Are you aware of court considering whether or not there's bad faith if an employer provides only the ESA minimums despite knowing that an employee is entitled to the greater common law damages. Is that in and of itself bad faith conduct that can give rise to extraordinary damages?
I'm going to say no. And I'm going to say no, not just because I see it happen a lot, but because the starting point would be the employer's liability for common law is only for what exceeds the statutory entitlements. And there are a number of things that can affect that common law liability. The fact that the employee might receive an award from a court of 12 months or 24 months or something like that doesn't mean that that employee doesn't have a duty to mitigate. Doesn't mean that that employee may have other earnings that would reduce the liability. So at the time of termination, neither the employer nor the employee will be able to predict the future and know how much the damages are. So the idea of paying whatever the lawyer on the other side for the employee says is the common law liability, I don't accept that, because we cannot predict the future. It may very well be that all of those damages are mitigated, or some of those damages are mitigated. And so from my perspective, I don't think that there is any risk of a finding of dishonesty or a failure to act in good faith in that scenario.
And Chris, maybe I can jump in further to the Galea case that we reviewed. Totally different circumstances if we've got a contract that says you're entitled to X and X exceeds the ESA. Breach of that contract could very well attract the type of enhanced damages that we were talking about earlier today. Different scenario, but similar circumstances. So another good question here from anonymous attendee, the anonymous attendees here at 8:58 a.m. If you know you are going to terminate someone without cause due to restructuring, is it best to terminate before or after vacation? And then there's a comment here, taking an extended vacation to go overseas to get married, which has nothing to do with the termination, want to avoid damages altogether. Any thoughts on that? Perhaps Jordan, you can take this one.
Sure. Well, I think a key point here is that the extended vacation to go overseas to get married did not have anything to do with the termination. And if the restructuring is genuinely for business reasons, it doesn't matter when the termination is, whether or not it's on vacation. Forget about this hypothetical scenario. We actually see this often when restructuring decisions are made when employees are on longer leaves of absence. Maybe for disability leave or maternity leave, and that's where it gets a little bit more risky of potential claims for extraordinary damages. But if there's, in this case, in these situations, it's critically important to have documentary evidence to support their reasons and timing for termination. If a host of other employees were impacted by this restructuring at or around the same time, and there's evidence to support the decision-making process, et cetera, in advance of the timing of termination, that will protect the company from exposure to these damages.
And I want to sort of echo what Jordan is saying in terms of timing of announcements. I am not a big advocate of not announcing those people that are impacted in a restructuring at the time that the restructuring occurs, despite the fact that they may be on leaves of absence for whatever reasons. There may be circumstances where that is the appropriate way to proceed, but I would say normally that's not the right approach. And I say that because if the person is legitimately included in the restructuring and we don't announce that they are among the employees affected by the restructuring, but rather wait until that person is ready to return from their illness leave of absence or from their vacation to be married in a foreign country or whatever it is, the immediate reaction of that employee is that you are now terminating me because I have recovered from my illness or because I've returned or I went away or whatever it is. And now we're having to defend the position that in fact they were affected by the restructuring originally. And it looked to the outside world as though we are manipulating things and now including them when they weren't originally included. We may have all the evidence in the world to show that they were on the list, so to speak. But I do believe that there is, while you want to be empathetic and while you want to be, you don't want to affect someone's recovery from an illness or the joy that they would have from a wedding, from an employer perspective, I would not want, as a sort of general position, to compromise the employer's ability to defend any claim while trying, or for the reason of trying to be sensitive to that employee situation.
Excellent observations, both of you. Maybe I can take us back in time a little bit to scenario number 3. Actually, Ayumi Bailey in the comments had a great question. Should Jill contemplate contacting the board chair or the board's HR committee to advise that Karen is a liability to the company? This one came up during our fact pattern review. Any thoughts on that?
Yeah, it's a good question and a tricky one at that. I don't know so much as it rests on legal advice as perhaps what the best advice is to managing this internal dynamic of the company. And like, to the extent that there are other reporting arrangements in place at this company, maybe it is a good approach to ensure that there's clarity and transparency as to what the conduct is going to be at the company. But at the same time, I'd be cautious as to not overstep any grounds. And Karen is obviously a hothead, and I wouldn't want to step on her toes and do anything that might get Jill in trouble in the eyes of her direct supervisor.
And if I can add, Jill, and not just Jill, every HR person is in a difficult spot in a scenario such as this, where you've got a manager who may be acting reckless with respect to the advice that they have been given both by HR and potentially by outside counsel or internal counsel. And I think the real crux spear point of the risk is where Jill believes that the advice or the conduct of Karen amounts to harassment under the company's harassment policy. If there is a genuine belief that this behavior is triggering or is satisfying the definition of harassment, then arguably Jill has an obligation to report that to whomever the right person would be. Where the CEO is involved, potentially it is the board. But there are situations every day, my suspicion is, amongst the folks that are on this call who are living in that HR role, where they have a manager who is not taking good advice, a manager who is acting somewhat cavalierly, if not recklessly, about how they are interacting with their employees. So I think that is something that needs to be considered. I see that we're out of time.
Absolutely. Maybe we can turn it over to you, Elisa.
Yes, thank you so much, Chris, Tushar, and Jordan. That was a very informative presentation. Thank you. So our next webinar is coming up on October 26th. We'll be discussing the perils and pitfalls of fixed-term contracts. So keep your eye out for that invitation. It will be coming to your inbox shortly. Your feedback is always so important to us. So if you could take a moment out of your day today, this morning, to complete our survey, which you can access by just taking a screenshot of that QR code on your screen, we would greatly appreciate it. And I just want to say thanks again, Jordan, Tushar, and Chris. That was an excellent presentation. Thank you again. And I hope everyone has a great day.